everyone. I'm Kristin Nealey Meier, and I'm going to talk to you today about recent developments in Washington state law. I know often you also get a federal update, but there is so much going on that we decided to split them up. So we want to start today with some legislation, since this is probably the area that impacts employers the most this year and will also impact you the most next year. As most of you probably have seen, at least those of you who have minimum wage workers, once again, the minimum wage is going to increase on January 1. It will be $16.28 an hour. And there is also some flexibility for teenage workers for those of you that might be hiring those. And also just keep in mind for those of you who are looking at exempt versus non-exempt employees, there is, of course, the salary test, which will be $67,724.80. So for those employees that are sort of close to that salary, you may want to take a look and make sure that you are classifying those employees correctly. Most of you hopefully know that when you're posting jobs, effective last January 1st, 2023, Washington employers who have 15 or more employees must disclose the wage scale or salary range for all your specific job postings. Now, this doesn't mean that if you say, hey, we're hiring, generally that you have to include that information. But if you have any specific job descriptions for which you are posting, whether it is externally or for an internal transfer, you have to provide that information. And for the internal transfer, you don't have to automatically provide it, but upon the request of an employee, you must provide a salary range. Now, recently, and I would say in the last 2 weeks, I have seen in King County alone multiple proposed class actions for companies who did not post a wage scale or salary range for their postings. So this isn't something that you can think about later. It could have actual tangible consequences of the type of a lawsuit filed against you if in fact you do not disclose a salary range for your positions. And to the extent you need some help in terms of what information to post, because you also need to provide benefits and other compensation, we would be happy to help. This is a forward-looking statute that was will be implemented January 1st of 2024. And this relates only to hiring. So if you are hiring an applicant and you have a pre-hire drug screening test, you cannot refuse to hire an applicant if that drug screening test identifies non-psychoactive cannabis metabolites, or you learn somehow of an applicant's prior off-the-job use of cannabis. A lot of this relates to different types of cannabis products that are on the market that may not have any impact on an employee's ability to perform their job. This also does not apply to employees that you currently have employed, specifically those that have safety-related regular drug screens or other types of drug screens that you use for current employees. That is not implicated by this particular statute. But just know that this is something to look out for when you are screening new candidates. Another statute that was recently passed that went into effect on September 3rd is just a slight expansion of unemployment benefits and the definition of necessary quitting voluntarily. That does not disqualify an employee from obtaining benefits if there are other family members that employee had to take care of, and that is what caused the resignation. I don't know how many employees this will apply to, but something to keep in mind in the event you receive information from the unemployment office about benefits a former employee is applying for. Also, a recent statute that went into effect July 23rd of this year is that employers may not search an employee's privately owned vehicle in the parking lot, in the garage, in an access road to those areas. There's some very, very narrow exceptions to this relating to safety, but for the most part, an employer does not have the right to search a vehicle, even if you suspect stolen goods, etc. There's other methods that you will have to utilize in order to go through a vehicle of your employee. This also does not apply to employer-owned vehicles. Those are employer property, and so you can search those if they're on employer property. Another potentially impactful statute that went into effect on July 23rd as well is there's now a privilege, which means the employer cannot obtain information about communications between a union representative and an employee that the union represents. I don't know how many of you have union represented employees, but if you do, and you're trying to find out information about, what communications, you're doing an investigation, you have to be very careful about the communications that you ask about and the information that you receive, because you no longer have an absolute right to get that information. And finally, there is now, at least as of January 1, 2024, employers are going to be able to ask ESD to get some information about an employee's approved family medical leave, including what I have on the screen here, the type of leave, requested duration, whether the employee was approved for benefits and was paid benefits. And this can be useful because the communication from employees is not always stellar, especially if they are really struggling with whatever reason they had to take leave in the first place. So when you're administering the leave according to your internal policies, and there's a hole in the information that you have about why the employee was granted leave, whether the employee was granted leave, and if you do any sort of additional payment to true up to their salary, you can get the information about what was paid. But you cannot use the information for anything other than administrating your own internal leave under established employer policies. You can't change your policies based on this information. You can't take any action to discipline an employee, even if they've provided you different information than they provided to ESD. So you need to be careful about how you use the information that you received, but you can, thankfully now, at least be able to get the information that might have been missing before. And I just wanted to give you a heads up. We don't usually tell you what statutes do not apply to you, but we have had some questions about the My Health, My Data Act, which is pretty comprehensive and very restrictive about health information that is collected by websites. It's collected by, different, Apple Watches, etc. But that applies only to consumers and consumers' health information. It specifically, in the definition for consumer, excludes the employee-employer relationship. So that's at least one statute that you don't have to worry about complying with as an employer. Now, I want to move to some employment law cases. There were fewer of these than legislation that impacts Washington employers. And the first one is Alaska Airlines versus L&I. And this was related to a collective bargaining agreement. And essentially, the Washington Family Care Act, which allows an employee to use their sick leave to care for a family member, was in some conflict with the terms of a collective bargaining agreement. And essentially what the court said after several different appeals to several different courts is that the collective bargaining agreement applies, and only in very narrow circumstances will this state law replace any terms or have the employer take any other action. Again, if you do not have collective bargaining agreement for your employees, then this case is not going to apply to you. And it was a very detailed analysis, but what it did was ensure that the Washington Family Care Act was ruled to be in deference to collective bargaining agreements, and that the goal is to leave those collective bargaining agreements in place to the extent possible. Greenfield versus Department of L&I. This case involved a volunteer for the ACLU. And he was basically an intake intern. So somebody would call the ACLU and say, this happened to me, what can I do? And the interns would provide resources or refer out to an ACLU lawyer. The intern said, I'm thinking about going to law school. I think this would be a good experience for me, but was never paid, never discussed payment. And none of the other interns in this position were paid a salary either. So he left, and then he filed a claim against the ACLU, claiming that he was not paid under the Washington Minimum Wage Act. And the court said, no, you were an intern, you provided gratuitous services to a nonprofit organization, and thus you were excluded from the definition of employee under the Minimum Wage Act. So those of you that are nonprofits, this is helpful for you, but you still need to make sure that any non-paid interns are actually providing gratuitous services and not performing a function that is normally one that is paid. The last one, it shouldn't impact any of you, because I would hope that none of you, certainly if you've asked us, would make this kind of claim, but a payroll company had an employment agreement with one of its employees that required the employee to waive benefits under the industrial action workers' comp framework. And the court said that was frivolous. There is a specific statute that prohibits the employer from requiring a waiver of rights and benefits under that statute, and dismissed the claim, granting the employee attorney's fees and costs. So be mindful that you need to be very careful when deciding whether or not you're going to file a lawsuit. I blame the attorneys, frankly, in this one for allowing that to move forward. Just a couple things coming up and something to be aware of. This is probably the most important. There's a putative class action against Solgen Power LLC, claiming that it required its employees to sign non-compete agreements that did not meet the minimum threshold of the 2020 non-compete law, which we have talked about for several years. And the big deal about this is, even if you make them sign, even though you don't try to enforce it, there is a certain possibility that you will be required to pay $5,000 plus attorney's fees for each agreement that you require an employee to sign that does not meet the thresholds. So it's pretty early on, but something to be very wary of, and frankly, to look at your current non-competes to see whether they comply. What we see coming up in the next legislative session is probably more requests and attempts to provide private rights of action for several different current laws that allow only agency action, and you can see them here. We'll see if they can pass this time, but it's something that we're watching all the time. And to the extent that something comes and is made into law that would impact you, we will certainly get an alert out to try to educate you as soon as possible.